I was never a Boy Scout, but I am a big fan of the scouting motto, always be prepared. You can have a good plan, you can set up who's going to make decisions for you. If you get really sick, you can decide who's going to settle your estate. You can decide who are the people you really want to receive your money and property when you're gone, but always have a backup plan. I'm Patrick Cawley with Keystone Elder Law in Mechanicsburg, Pennsylvania, and I want to tell you about a family who came in to see me recently. Mom and Dad had done some estate planning. Dad now had advanced dementia and was in a nursing home. The only troublesome part of their estate planning is that Dad listed only Mom as his power of attorney. This was good in the sense that Mom was able to take care of legal and financial and healthcare decisions for Dad now that he has dementia. But the adult children were worried. They were saying to me, well, Mom is in her 80s. What happens if Mom's health deteriorates and she can't make these decisions for Dad? Can Dad name somebody else as a power of attorney? The answer is no, because with advanced dementia, he does not have the cognitive capacity to execute new legal documents. So then their next question was, well, can Mom sort of propose somebody who would take over for her under the power of attorney? The answer is no. The only person who could make that decision is Dad, because it's really Dad giving up his right to manage his own finances, his own healthcare decisions, and so forth to another person, so only he can name that person who would fill in if Mom could no longer do it. So with one more question, the adult children said, well, what happens if Mom dies? How do we make Dad's decisions for him? The answer is guardianship. Now that's expensive, it requires going to court, it's an invasion of the family's privacy. It'll get the job done, but it's not desirable. So I was very happy to see that Dad had done some estate planning, he had a power of attorney, but I would have been had a better feeling about the situation if Dad had not just listed Mom, but listed somebody else who could fill in for Mom in his power of attorney should Mom be unable to serve in that role. But he just hadn't, and I'm not sure why, but that we had to work with what we had. So this same principle, have a backup plan, applies across all of your legal planning. So if you are naming guardians for minor children, have a backup in case the people you really want to be those guardians, for whatever reason, decide they don't want to do it, they can't do it, maybe they die. You always want a backup. Your named beneficiaries in your will or your trust. Who's going to get your property if your child dies before you do? Or what happens if the trustee decides, I can't handle the responsibility of managing your estate? Who's the backup? You always want to have a backup, even if it's not likely that a backup will be needed. List one anyway, because you're making a plan that's going to have a number of contingencies in it, because you just never know how life is going to turn out. If you have questions about how your plan might work, how you should have backup plans built into your legal planning, please get in touch with me. It's KeystoneElderLaw.com. You can email us at info@KeystoneElderLaw.com. Leave a comment or a question to this video, and we'll be sure to get in touch with you.